A search of Mrs. Flack's rented premises was undertaken to assist an investigation being conducted into a possible offence involving the possession of prohibited imports of narcotic goods. The warrant was based on suspicion that Glenn Flack had been involving in drug-related offences. The search was lawful. A briefcase containing $433,000 was found. Upon discovery, Mrs. Flack was quite surprised with the contents and said that she had never seen that money before. The bag and the contents were taken away in execution of the warrant. However, no person was thereafter charged with any offence. Mrs. Flack requested that the bag and contents to be returned to her. The National Crime Authority refused and claimed that Mrs. Flack did not have sufficient title to sue for it. Initially, the response was that the goods might be needed in evidence in contemplated proceedings against Glenn Flack. For 3.5 years following the seizure of the evidence, the excuse had worn a little thin. Justice Hill provided that the statutory powers of the Australian Federal Police to seize and retain goods for a reasonable period did not authorise continued retention beyond the time necessary for investigation or prosecution. Mrs. Flack had the right to exclude in a position as lessee. This included the ability to exclude others from all goods which were in or on her property. The police, in executing the warrant, were clothed with a statutory right to seize and take away any property regardless of whether any other person had possession or ownership. Section 3ZV of the Crimes Act provides that the seized goods must be returned if the reason for its seizure no longer exists or it is decided that it is not to be used in evidence, unless the thing is forfeited or forfeitable to the Commonwealth or is subject of a dispute as to ownership. Provided in the Australian Property Law Cases and Materials at page 163, is it reasonable that Mrs. Flack, who clearly manifested shock and horror when confronted with the presence in her home of these goods, and who quite clearly would not have announced their presence had she known of them, be nevertheless entitled or obliged, the presumption relied upon, to assume possession of them? This would be to impose upon her possession of unwanted goods. The relevant elements of possession should be clarified. All that is required to satisfy intention to possess is an intention to possess something for the time being. There is no need to intend to possess an item or possess it, to own an item or possess it permanently. It is possible to possess something without knowing it exists. If you intend to possess a suitcase, then you intend to possess its contents, even though you do not know what it contains. The plaintiff's intention to possess her home meant that she intended to possess the things inside it. For land and goods, both of which may be possessed by someone other than lawful owner, property rights in the sense of ownership must be distinguished from mere possession of the land or goods. Even though the latter may give rise to qualified legal rights, actual possession may give the possessor better rights than others whose interest does not derive from the true owner. In matters concerning possession acquired by consent and obtaining the right to possession, there is a right to recover possession if the true owner cannot be found, thus transferring the title of possession to Mrs. Flack. The common law provides protection against unauthorized interference or detention of chattels. Wilkes and Wood sets out an enduring common law principles against unauthorized search and seizure, later reflected in the Fourth Amendment of the United States Constitution. The amendment enforces the notion that each man's home is his castle. As provided by Justice Tamerlan in the present case, it is secured from reasonable searches and seizures of property by the government. Justice Heery noted a common law restriction on the seizure of property under warrant. A common law, an article seized under warrant cannot be kept for any longer than it is reasonably necessary for the police to complete their investigations or preserve it for evidence. As Lord Denning M.R. said in Guy and Jones, 1970, as soon as the case is over, or it is decided not to go on with it, the article should be returned. The main issue was whether Mrs. Flack had the requisite title to sue, which coincided with her right to have the money returned as her lawful property. The government considered the lack of access. Mrs. Flack admitted that she had not been that high up in the cupboard for about 13 years. However, that did not mean that she relinquished a general intention to exercise control over the house and everything in it. Further, Harry J. knows that there was no general power of the state, either a common law or statute, to forfeit goods simply because they appeared suspicious. Consideration should be given towards the rental status of the home, which has connections with other arrangements, such as a dwelling occupied through an Airbnb arrangement. This matter relates to the element of control. Whether premises are residential premises of which the plaintiff had exclusive possession as owner or lessee, then the judgments of the federal court indicate that an intention to exercise control over the premises and all items in those premises is presumed. Since Mrs. Flack was the tenant of an ordinary residential house of which she had exclusive possession in law, that fact was sufficient to establish the requisite manifestation of intention to possess all goods on the premises. The case is authority for the proposition that an occupier of land may have sufficient title to goods to sue in conversion, notwithstanding that the occupier did not know at the time that the chattel existed and was in his or her possession. The complexity of the Airbnb arrangements concern the question lease or license. The recent case of Swan and Uecker, 2016, considered this. In the Victorian Civil and Administrative Tribunal, it was held that the tenants were only granted licenses rather than leases to the Airbnb guests. However, the Supreme Court overturned the VCAT decision, deciding that the tenants had let the whole apartment. The difference between lease and license is an important distinction to make. It can determine whether the person with the right also has property rights. It provides a need for inquiry into whether the Airbnb arrangement can give the guests the legal rights similarly to titles awarded in the circumstances of Mrs. Flack. The consideration of legality may have provided a scope surrounding the differences between rentals and whether the same element of possession applies. It is presumed that in an Airbnb arrangement, the same law would apply, considering that both critical elements can be applicable. In circumstances of the Airbnb arrangement, you would be able to show intention to possess items of luggage and sorts. However, it becomes tricky when satisfying the element of the ability to exclude. The legality and licenses or leases of other arrangements would be pulled in consideration. This consideration would be boiled down to the question, who has the better rights?